Hey, good afternoon, everybody. My name is Neil Kalin. I'm here for another uh, issue of What's Up With Us, the real property law section of the California Lawyers Association monthly, I don't know, talk show, I guess. We've got we've got a really nice event for you this month. I'm going to be joined by Frantz Farreau, who anyone who has been on here before may recognize Frantz. He's a regular host. And we have a special guest host today, Tom Lombardi. Tom joined us. I see you there, Tom, in a very nice, clean looking, background there. Is that a real background, Tom, or is that one of these phony ones?
100% artificial, Neil. Thanks.
It's artificial. Well, it looks good. I like the nice
background.
Very nice. Got some depth going there. That's really great. We also have an interviewee who is joining us. She's already on the line, and it's Pamela Brown McGill, and we're gonna interview Pam in about 15 minutes or so. But Pam is welcome to join us, and Frantz will be conducting the interview, so we'll all learn a lot more about Pam in a few minutes from now. So, but Pam, say hello to everybody. There you go. Nice wave.
Hello, everybody.
That's great. So let's see, what are we going to be talking about today? Here we go. Well, we did our introductions. We'll just do a real brief update on the CDC eviction moratorium. We'll start off with a couple of cases that I thought were interesting. One dealing with whether a trustee or the trust itself is a landlord. Another dealing with the ADA and service animals. Then we're going to go into our interview with Pam. And then there's one of the things Pam's going to talk about is the recent law dealing with homestead exemptions. So, or a modification to the pre-existing homestead law. And then we're going to round ourselves out with a couple of more cases and talk about, what events are coming up to make sure you're prepared. Things you could look at your schedule and hopefully plan some things, write some things down. And of course, as always, if you have any comments, suggestions on what we're talking about or what the real property section should be doing for you, we're happy to hear from you. And of course, our next What's Up With Us is next month on May 20th. So let's get going. So again, usually this is our all-star cast, me and JR and Ashley, but JR and Ashley not here today, right? They've been replaced by Frantz and Tom. So we're happy to have everybody. They're looking really good, I must say. They've got much better pictures than I do. I've got to work on that for myself. So here we go. Let's start off. We're going to start talking about just a CDC eviction moratorium update. And just wanted to let everybody know, in case you haven't seen it, which is the CDC. So this is the federal eviction moratorium for residential properties. Was supposed to expire at the end of March. It's been extended through the end of June. And with this extension, for people who have not already provided, or for tenants who have not already provided landlord with a declaration, the CDC came out with a revised declaration form. So if you want, you can just copy the link that I have there, paste it into your browser, and get the information where the CDC is extending the period and the revised form. Wanted to mention, last time I talked about 3 cases that came up. Last month we talked about the Turkle case and the Chambliss case that reached different decisions on whether the CDC order was enforceable or not, different grounds entirely. But I wanted to mention I came across some other cases. So there's a lot going on in this area. the 5th district. We've got 6 district cases. We've got an 11th district case, and I did not get a chance to read through the 8th district case, so I don't know which way that one came out, but you can see we have a lot of conflicting rulings. So I said there's good news and there's good news about the extension of the moratorium. Obviously, if you're a tenant, that's good news, right? Especially if you're a tenant and you're in financial distress, you've got more time to recover. Maybe now that there is all of this money out there, state and federal money, maybe you can find that you are eligible for some of that money. You apply through the state. The California system for money has been up since, trying to remember when it came up. I think the end of March, and different localities have been coming up throughout for the last couple of weeks. So maybe you're able to get some money in, or if you're a landlord and your tenant hasn't been paying, you have the ability to apply too. So maybe you can get some money during this period of time where the tenant cannot be evicted if they provided the information through the federal form. So what's the good news? Well, the other good news, that's one good news. There's other good news too. We thought all of these cases might be moot if the CDC eviction order expired at the end of March. And while we're all hoping there's not going to be another pandemic for another 100 years, you never know. And it would really be nice to have some decisions at the appellate level that address what can be done and what is going beyond authority, whether it's beyond statutory authority or whether it is a violation of the United States Constitution. It would be nice to get some appellate decision on these things one way or another, so that if another issue comes up, there's some guidance as to what the government can and cannot do. And with the extension through the end of June, some of these cases that might have been deemed moot, we actually may get some appellate decisions on them. So we will find out about that. That's really all I wanted to say, unless my colleagues have something that they would like to add. You know what, sorry, colleagues, before you do that, just want to remind everybody, this slide just deals with the federal law. California has its own eviction moratorium, which has also been extended through the end of June. So really, no matter what happens on the federal level, none of that affects California's right as a state to enact their own eviction moratorium. But it's possible that some of the analysis at the federal level might wind up applying at the state or local level. That's it for me. Tom, Pam, Frantz, anything you want to add?
Yeah, I'm just curious, Neil, in terms of the federal law, does it preempt California? Does California control? Is it the broader statute, more protective statute that governs? How do you reconcile the two frameworks?
Whichever is more protective. And in the cases that I've read, the ones that were cited, Turkle, Chambliss, Skyworks, I haven't read through all of the other ones yet. They explicitly state that their holdings do not impact the state's ability to enact an eviction moratorium under the grounds they could do so for the health and safety of their own citizens. Okay. Did I answer your question, Tom?
I think you did, and this is of course only relates to residential evictions in terms of the state framework and the federal framework. So yes, there's a whole other world out there too on the commercial side.
Yeah, a whole other world on the commercial side. The federal law, the state law deal with residential, but there's a lot of localities that have adopted their own commercial eviction moratorium. And of course, everyone needs to, this area is just so fraught with danger for anybody who steps in that you really need an experienced landlord tenant attorney, whether it's on the commercial or the residential side.
And I got to tell you, that's great advice, Neil, for everybody, because what I found myself doing, and I'm only focusing on the commercial side, but literally if a week goes by and a client calls me about a jurisdiction, has a question about a jurisdiction I might have touched on just a few weeks ago, I go back and I research, because it is so dynamic, and these ordinances and these laws change so rapidly. You can't give advice about it without double checking. So that's just a word for the wise too on this area.
Yeah. So Tom knows I advise in my day job. I advise real estate agents, but even lawyers that are in this field, like you say, Tom, you've got to look at this constantly to figure out if there's been some update or some change. Just because there's a lot going on. There are, by the way, I'm aware of several cases at the state and local level challenging the state and local rules, but I have not seen any of those reach the appellate level yet.
Yep, correct.
Right.
All right, well, let's go to our first case then. Boschernitsen, I'm gonna hope that I pronounced that correctly, versus Bach. And this is kind of an interesting case. So the Boschernitsen and Vinodor, two plaintiffs, lived together, and they wanted to evict Bach and her family from a 2-unit building under San Francisco's move-in ordinance. It allows you to move in a family member. And I believe they were going to be moving in the mother of one of them. And it was, like I said, it was a 2-unit building. Under San Francisco's ordinance, in order for it to apply, the landlord must be a natural person or a group of, I should say, of natural persons, which makes sense, because how can a non-natural person, how can an entity, bring a family member in? So a year before the attempted eviction, the property was placed into the plaintiff's living trust. Defendant found out about it, demurred to the complaint, said, well, wait a minute, the landlord is not a natural person. The property is in a trust. Trust is not a natural person. The trial court sustained the demur, said, hey, you're right. A trust is not a natural person. Therefore, the landlord cannot pursue the eviction of a family move-in pursuant to the San Francisco ordinance. And a lot of cities have ordinances like that, and they're all very similar, right? They allow, a parent to move in, or a child to move in, or a grandchild, some close family relation. So the case was appealed. What did the appellate court say in the appeal? That says, well, kind of a reminder that a trust is not a legal entity, but rather a fiduciary relationship. Nothing new about that statement right there. Trust cannot sue or be sued or hold title to real property. Matter of fact, I remember years ago I was talking about some cases in the arbitration mediation context, and there was a case where the trust was named as a party in the arbitration, and then the winning party tried to enforce it but couldn't enforce it because they named the wrong person. They should not have named the trust. They should have named the trustee. So some people just don't think about the fact that there really is a distinction between the trust and the trustee. So here we have another statement. All actions on behalf of the trust are by and through the trustees. In this particular case, the appellate court noticed that, well, wait a minute, the deed actually named the plaintiffs as trustees. So the deed was not in the name of the trust. The deed was in the name of the individuals as trustees of the trust. Something that I see gets done wrong all the time. Parties go to their estate planning attorney. They want to put their property into a trust. They change the title from the individual to the trust itself, as opposed to putting title in the name of the trustees of the trust. But in this case, they were named as trustees. They were also the settlors of the trust and the beneficiaries of a revocable living trust. So the appellate court said, well, wait a minute, these people are individuals. They were named as an individual on the deed, as both the settlor and the beneficiary of a revocable living trust. It's really just a holding mechanism. It's not a title issue. They were acting in their capacity as individuals, and they did have the right to go forward and pursue the eviction under a family move-in part of the San Francisco ordinance. So some of what's in here, simply restating, existing law, but restating existing law that I think gets missed all the time in the day-to-day practice of law. So I thought it was an interesting case, and I thought it would be worth mentioning to our real property members that are listening to us today. Tom, Frantz, anything that you think is worthy of adding here?
I have to. Oh, sorry. No, I was going to say this idea of. Oh, thanks. This idea of I see this all the time on title documents that properties are put in the name of a trust and not the trustee, Bob, whatever, as trustee of whatever trust. So that really is a mistake that people make all the time. And I think just like many things in law, it's not a problem until it becomes a problem. And so I think this case really does a really nice job of helping us understand this is how this becomes a problem, because imagine you put this you are the attorney who put this not in the name of the trustee, but the trust, and then they want to move in, and that now suddenly is malpractice for you. So, it's really important to remember these little details that people forget about all the time.
Yes, as an attorney who also does estate planning, I like this case as well, guys. I love that it not only, I like the ruling in it, but I do like that it took a moment to educate those out there that every now and then kind of miss the point. So I think that this case actually serves a couple of purposes.
Pamela, I agree, and Neil, I think you hit the nail on the head too, because this is really a restatement of law that has been in existence since the Magna Carta, but nobody remembers or recalls it, and so the problem is, I see this not only on deeds, but you see it within leases and also in litigation. It's you see it like people proceeding with pleadings like this, without really thinking through what they're doing, and then they have to amend. So the court, I think, was trying to take this opportunity. I think if anybody hit the books, they'd understand this concept. But the court is clearly taking this opportunity to put it out there so that people don't make these, so that it's like, we're going to restate what the existing law is. It is interesting to me that I didn't look at the underlying record, but when this issue came up initially, let's assume, here you actually had, the deed was done correctly. But let's say the issue comes up where the deed is done incorrectly. Could the litigants have just quit claimed to a trustee to cure all these issues, rather than going through, this lengthy, like some sort of lengthy appellate process? That would probably be the solution that I would be looking for, if there's actually a legal document that you can amend, to cure the issue, rather than persisting in litigation. They didn't have this. They were actually, the plaintiff was correct throughout the course of this case, and unfortunately they had to, go through an appeal because the trial court went the other way incorrectly. So neat case, valuable reminder for I think all real property practitioners.
Great.
Yes.
Thank you, everybody.
Well, actually, Bernard, I had a question, and he said, what about single member LLCs where the LLC is ignored for tax purposes? And as far as I understand, those sorts of actual entities are actual legal entities as opposed to a trust, which, as Neil said, is a fiduciary relationship between two parties. So I imagine that this case wouldn't apply, but my question, I guess I'll pass this on to everybody else.
I agree with your analysis, Frantz. I think LLC is fundamentally different from a trust. I agree with your analysis.
I don't think there's any correlation between the tax status and the legal substance of that being a recognized entity. But I do think ultimately you got to square that with whatever local ordinance rent control there is in effect. So I'm not sure. I'm not familiar with the rent control ordinances, but I assume that in the case of San Francisco, it would not be treated the same as a trust.
And I see Pam nodding. So I'm going to move on to our next case. And we have CL versus Del Amo Hospital. Thought it was an interesting case that might have broader application, which is why I brought it up here today. So here, the CL, the plaintiff, was diagnosed with PTSD. She obtained a dog. She trained the dog on her own to perform services. I list some of the services there that she had the dog perform. Why did she need the dog to perform some of those services? Well, she had a lot of anxiety, a lot of stress, and when the dog performed those services, it helped her cope with those issues that she was experiencing. She started to take a dog to a training class, but it was in another city. It was costly. Several of the sessions that you would have to attend to get your dog officially certified by a third-party group were really irrelevant to the kinds of services that she needed the dog to provide. So she did not go through the whole training class. She was going to the hospital for some inpatient treatment, and the hospital denied her the right to bring the dog with her. Their reasoning was actually the dog's presence would interfere with the therapy. The kind of therapy she was going through was to help her basically overcome some of her anxiety and some of her symptoms. And the hospital basically said, having the dog there is going to be, the dog is essentially going to be a crutch and it's going to interfere with her treatment. Well, CL thought that she should have the dog there, brought a legal action against the hospital. The trial court, among its rulings, said, well, wait a minute, the dog did not qualify as a service dog. So remember, there's two kinds of assistance animals. There's service dogs, right? And there's several names for them, but companion animals is what some people call the other ones. Animals that just their mere presence alleviate a person's disability, as opposed to a service dog that is trained to provide specific tasks. The case is brought under the ADA, which prohibits discrimination against individuals with disabilities in public accommodations. The hospital is a public accommodation. There was a reminder here that the disability can be physical or a psychiatric disability. And as the court was pointing out, the appellate court in this case, so what happened, I skipped over. The trial court said, no, the dog needed to be certified in order to qualify as a service dog under the ADA. The appellate court was reviewing the law and it says, well, wait a minute, the ADA does not actually require certification. It just requires that a service dog has functional behavior, that it performs certain services. So the appellate court remanded the decision. This is a real property section. Why are we worrying about this? Because essentially the ADA rule is the exact same thing as the fair housing rule in California. And so there's a lot of people that bring, assistance animals, whether they're service or companion animals. And I know companion may not be the right phrase that's used these days. But very common in California to have fair housing complaints dealing with disabilities. In fact, I was just listening to a presentation earlier this week from the Department of Fair Employment and Housing, and a third of all of the allegations that are raised in the complaints that go to the DFEH have to do with disability. So again, the state law for Department of Fair Employment and Housing really applies the same rule as the federal law, as was explained here with the ADA. So I thought everybody should be aware of that. If the dog or the animal provides services for the individual with the disability, a third-party certification is not a requirement for that animal to be considered a service animal under the law. And I'll turn it over to my colleagues if they want to add anything. Not hearing anything, we're going to move on.
Yes, let's move on.
A good reminder case. We're moving on. We've got an interview with Pam Brown McGill. Pam already spoke up, so we're so glad to have you speak up, Pam. And I'm going to turn the mic over to Frantz, who's going to conduct our interview. Welcome, Pam.
Thank you.
Welcome, Pam. Seems like we moved on. So Pam is a bankruptcy attorney, and she is going to talk to us a little bit about the homestead exemption, what it is, and why we should care. And I think one of the reasons why we as real property attorneys need to think about the homestead exemption, particularly now, is because, people might not be able to pay their mortgages right now. So either they own rental properties and they're relying on that rental income to make their mortgage payments, not on the properties that they own, but on their own primary residence. So it's kind of what they use as their source of income. And also just, some people might not be able to pay their mortgages now just because COVID has been bad for people and their income, at least certain people. So the homestead exemption is really helpful in sort of allowing people to protect their primary residences or protecting their homes when there are creditors who are trying to go after assets. And so Pam will talk to us a little bit about what that is and why that's relevant. So
Pam, if you don't mind me interrupting you just for a moment, Frantz. So Pam, maybe you can clarify when you start talking, which is, does the homestead exemption protect one from secured debts? Because Frantz was talking about, homeowners that may not have been paying their mortgage, which are usually secured by a lien on the property.
Right.
Or does the homestead exemption only protect against unsecured debts, which people may also have difficulty paying these days because a lot of people have lost, a sizable amount of their income. So I'm going to turn it back to Frantz and Pam. I just want to make sure that we get a clarification on that issue.
By all means, we'll definitely clarify it. So Frantz, are you ready for me to take it away, or are we going to do our...
Yes,
tell
please do.
Tell where we at with this. Okay, so just to back up a little bit, when we talk about the homestead history, ages ago, when people would purchase properties, well, when I talk about ages ago, I'm talking about like a million years ago, not really a million years ago. I'm talking about like the 1800s. Your home, you could go in and you could get government property, and that was your property, right? No one could come in and take it from you. So this has its history in our early beginnings, you might say. As time went on, though, the homestead exemption became codified in the code. And what it does is it allows you to protect a certain amount of your home's equity. We're not talking about what's owed, we're talking about what you own above and beyond that. And it doesn't protect against those secured creditors that are secured by your house. So let's get that clear. So there's lots of different type of secured creditors. You have your vehicle can be secured. There's sometimes a debate over whether or not your jewelry is secured. unless you go and put your house up as collateral for a $5,000 diamond, that's not going to count, okay? But what people do tend to do is they will get maybe a first mortgage, and then they might go get a second mortgage, and maybe sometimes a third mortgage. Those are secured against your home. We're not talking about those types of debts, guys. So sad, too bad.
Did we lose you, Pam, temporarily? Oops, Neil, you are
It looks like
silent.
Pam froze up, so maybe we'll just move on right now. And Frantz, if you could reach out to Pam and see if we can get her back.
Oh, am I there? Sorry, guys.
Okay, great.
Okay, you know what? I don't know what I do with my computers. I kill them, but I'm going to try to be quick because it's been giving me cues that it doesn't want to cooperate today. In any event, though, picking up where I left off, guys, why do we care? We care because people are unfortunately not only paying their mortgage, but they're falling behind on their other debts. And we don't want to be homeless, right? Yeah, it's one thing that I owe the bank because the bank owns my house, but now the creditors are coming after me because they want to pay for maybe the furnishings in my house. Guys, you're okay to an extent, right? Because our home values have gone up, but we will get to that in a minute. Going back to the homestead, though, in a nutshell, it's going to protect you against your creditors, again, for the amount over and above that you actually own. And it can also protect you in the event that you find that you might have to file bankruptcy, which is a great tool in the event that you need it. Getting into a little bit more specifics, we have two types of homesteads. You have your automatic and we have your declared. Automatic means just that. There is an automatic exemption that's been put in place because the government realized that even though it was there, people did not understand that there was an actual document that you would record that would apply this protection to your home. So what are the differences? And I'm going to back up. If you want to really read about it, go to Civil Code Section 704.730, guys. But what's the big difference? The big difference is here. If you have an automatic deduction versus like filing the paper, right? It's going to, if you file the paper, it's going to give you a little bit more protection. When I say file the paper, I mean record the homestead with the court, with the county assessors. And I'm going to apologize. Sometimes I do start talking fast and I start talking over myself. That is why I'm trying to slow it down just a little bit. Plus, my computer has me a little bit freaked out. Okay, sorry, guys. That it might go out on me. When we're looking at the amounts, I'm going to come back to the topic I started on, but in a second. I want to jump over to the amounts real quick here. Earlier, you would be able to protect your house and don't have a heart attack up to only like $75,000 for an individual, $100,000 if you're a couple, and then getting up to possibly $150,000 depending on your age and whether or not there was a disability. Well, our housing, what's going on here in California, and I mean, let's think about it. Is $75,000 going to protect anything, right? When we're looking at our equity in the homes. What that would mean is that if you had, say, a home and the value were, let's just say $500,000, and your mortgage on it, you only owed $100,000. What that would mean is that there was $400,000 on the table for creditors to come after. Okay, and you would only be able to protect like 75 to 100,000, maybe 150, depending on your situation. Okay, what does that further mean? What would that further mean? It would mean then that you would have to pay out the remaining amount to your creditors. And most people don't have that kind of money, so you'd have to sell your house. Well, here in California, we ended up passing AB 1885, thank you. And that raised the homestead exemption amount. And what it did was it decided to base that on where you live. So depending on where you live in California, that homestead exemption can actually go as high as $600,000. I believe here in San Diego, we are like there. Our home values are through the roof, and people do have equity. So what that means then is that you don't have, if you have went ahead and recorded your homestead paperwork with the recorder's office, then creditors are going to be hard pressed to try to come after, excuse me, come after you for those, for that additional equity in your house. And that stays in place for up to 6 months after even selling your home. So I know that was a lot of information, guys. I apologize if I started speaking a little bit too fast there, but my computer did have me a little bit freaked out that it was going to start doing its own thing. With all of that information, guys, ask me some questions because I know I have some holes there that need to be filled in.
So Pam, I have a question for you. I was a little bit confused.
Yes.
So about the difference between recording a homestead exemption and the automatic homestead exemption.
Mm-hmm.
In both cases, you get the same, I should ask the question. In both cases, do you get the same dollar value of protection?
Okay, this is the thing. You will still get the same dollar value. The big difference is that in one, if you have what's called a declared homestead protection, it's going to actually protect you from what's called a voluntary sale. Okay, meaning that you yourself are elected to sell your house and it hasn't been taken by creditors.
Okay, so
that makes sense. I may be a little bit discombobulated here because my computer has me like at a disadvantage here. Sorry, guys.
That's okay.
Well, it sounds
so I just want to understand.
Okay.
If I sell my home and I have equity and now I get that equity and let's say I put that cash in the bank, that cash could be attached by one of my creditors. Is that correct? Without a declared homestead.
Oh, without, yes.
But with a declared homestead, the amount that would have been protected from a forced sale is still protected from a voluntary sale. Now, do I have to use that money to buy a new home or is it protected regardless?
No, that money's protected regardless.
Okay,
and that's a whole different exception, which you're kind of thinking of, I think, which I won't get too far into because that's not my area. But remember, there are other protections in regards to taxes when you sell a primary residence and then you move that money into a new residence, right? So that's a little bit different. And so I won't necessarily go down that road.
Okay. Yeah. Frantz or Tom, any questions?
One of the things that I'm curious about, and I think this was an issue that crossed my mind under the older framework too, was if you're going to do a declared homestead, does that declaration is it valid as against a judgment creditor that existed prior to making the homestead declaration? Or does it have to be done in advance of a judgment creditor?
You know what? Thank you for asking that question, Tom. Exactly. It's not, boy, if those judgment creditors get in there before you do it, yeah, so sad, too bad. It does not protect you against those. So that's why it's unfortunate because a lot of people, again, don't understand, right, that it's there automatic, but you can actually take steps yourself to put this in force so that you actually have it declared to the world that, hey, look, there's a protection here. So if the judgment creditor beats you down there, to the recorder's office and gets that lien in place, then you're not going to be able to protect against that. Mm-hmm. Once you sell, they get their money.
But you can protect against that if you declare the homestead ahead of time.
Ahead of time, exactly. It needs to be ahead of time.
I mean, I think this is kind of a practical question, but if we have clients and we're advising them, maybe you should, if you're going to file a lawsuit or you're being sued and there might be a judgment or any of those sorts of things, like how much work is it to declare a homestead? Is it easy? Is it a lot of work? Is it simple?
You know what, it's a, excuse me, it's a fairly simple process. You can get the forms down at the recorder's office, and you just record it. That's it. It's just, I was just looking at it. It's like 1-2 page document. You fill it out and you can do it yourself. You don't even have to hire an attorney to do it. However, one thing that I believe that you do want to consider is that is the ramifications that once you do, file the homestead declaration, if you want to do things down the line, right? Like if you do later on decide that you do want to borrow against your home, things like that, then you may have to deal with it. Kind of similar to when we're dealing with the trust situation, we will put the home into a trust, but then if the trustees decide they want to refinance the home or take money out, they actually have to take it out of, their names as trustees, put it back into their names as owners, do whatever business they're going to do. And then once that's done, then they throw it back in.
Hey, Pam, this may be a stupid question, but I'm gonna ask it anyway. And
No
that
stupid
is,
questions.
does the homestead protection only apply to ones, what would I call it, primary residence? Because a lot of people have a second home. Would the homestead apply to a second home?
It does not. It does only apply to your primary residence. And thank you, Neil, for also asking that question, because I did mean to circle back around to this. So it does have to be your primary residence. So if you own several homes, it's not going to apply to the additional homes that you're using as rental property. And let's face it, for obvious reasons, correct? And the obvious reasons being that those homes are your business. If they're rental homes, they're business. And so the courts are not going to give them the same type of treatment that they're going to treat your primary residence, your main home. At the end of the day, our legislature, when you kind of think about what's going on with the housing, the eviction moratoriums, right? We really don't want to see people homeless, right? So we want to do what we can on a certain level to protect that integrity so that they, at a minimum, have a roof over their heads.
Yeah. Thank you.
We have a couple
I
more
said,
minutes with Pam. So Frantz or
yes.
Tom, either one?
I actually saw that Joel had his hand raised. So Joel, I guess if you'd like to unmute yourself and ask your question.
Do we need to unmute Joel? I don't know.
No, Joel should be able to unmute himself. I would need to find him in this list.
Joel, you should be.
It looks like he's unmuted to me.
Yes. Yeah, now he's unmuted.
Yeah. Or maybe he can type his question if that makes it easier.
Joel, are you there? Okay. Well, we will circle back to Joel if he is able to ask his question or if he wants to type it out into the chat.
All right.
Sorry,
Well, first of all, we want to, again, thanks, Pam. I hope you stick around for the last few minutes and contribute for any additional comments we have to make for our other topics. And if Joel writes in or somebody else writes in, we'll make sure to bring the question up to you.
Perfect. Thank you, guys.
Yes, thank you.
Okay, so let's just go over a couple of cases really quick here. We got Breslin versus Breslin. And this is a case where there was some potential beneficiaries of a decedent's trust. There was documents that were missing. Certain charities were named in another document that was found. So these charitable organizations were potential beneficiaries of, I think it was like a $3 or $4 million trust that was in a decedent's estate. It was unclear, the application of this other document. So the probate court ordered all parties to go into mediation. All parties were given notice of the mediation. Only 5 of the 24 charities decided to attend the mediation, And I think only 3 of them actually responded to the notice that they were given. Those that were in attendance, which included individuals who were not, the named charities, agreed to a division of the estate assets, leaving out all of those who did not attend. Went to the probate court affirmed the decision after and sent out notice of the confirmation. One of the named parties here is PLF, Pacific Legal Foundation. They were not the only one, obviously, that did not attend. After they got notice of the confirmed statement, they objected to the settlement. The trial court said, hey, you didn't file a response to the petition to determine beneficiaries. You did not appear at the mediation. Your objection is going to be ignored. That decision was appealed. The appellate court basically says, hey, a party who receives notice, who fails to participate in a court-ordered mediation, is bound by the result. In other words, if you're going to object, you had to have objected before the mediation was completed. Interesting, in this case, there was a dissenting opinion, and the essence of the dissenting opinion was simply this. The dissenting justice said, well, the court was really focusing on an issue of notice, right? Not a substantive issue, but the probate court's primary consideration in trying to figure out what to do with the decedent's estate is looking to the intent of the testator, the one who prepared the will, even though in this case all the documents were incomplete. But that's the paramount concern of the court. And any other nicety really needs to bend to the primary consideration, which is trying to comply with the intent of the testator. Obviously, that was just a dissenting opinion, but anytime you have an opinion where there's a dissent, it always makes, for an interesting discussion. Obviously, the majority did not feel that way. They said, hey, the parties had their chance. It's too late for them to object now. And that's really all I want to say. But, it dealt with, a lot of people have, trust. We have a trust attorney, a bankruptcy and a trust attorney with us today. So I thought it would be an interesting discussion, or an interesting case to at least bring up and make you aware of it. Basically, to me, the court just could have said, what? You snooze, you lose. That's kind of the basic holding of Breslin. This is Breslin.
Oh my gosh.
All right. Anything before we move on to our next case?
Yeah, real quick, Neil. I'm trying to peruse the case real quick. But did you say why they did not appear?
Yes, the party who was appealing did not appear at the mediation. That's correct.
But why? But do we know why he didn't appear? I'm just curious to know. I'm just like, wow.
It was not stated in the case. I have no idea. I mean, you could speculate. I could speculate. I didn't contact the parties to the case to find out. I imagine there's a lot of cases where, a potential beneficiary says, it's not worth my time, right? Maybe they didn't realize the size of the estate. I don't know. There's no indication in the opinion why the appealing parties did not appear.
Okay, I'm just kind of curious about that. I don't know. I guess, like you said, you snooze, you lose, right?
I mean, I think one of the things for me is that it appears that the court actually was attempting to bend to, meet the testator's intent by having these parties go to mediation, because it wasn't really clear what the
probate descendants is going to go up.
I'm sorry.
Go ahead, Frantz. I think somebody just had themselves on mute.
Oh, no, yeah, I was going to say, it really seems like they were actually attempting to try to do what the testator wanted by having this mediation, because it wasn't clear who the beneficiaries actually were. So on some level, I feel like the court actually tried to do what it could do, to meet the interest of the testator while still, you know, doing what a court has to do, which was kind of figure this out and close out the case.
Yeah, that's interesting analysis. I hadn't thought of it that way, but yeah, they really did go out of their way to try to get these potential beneficiaries to at least, you know, have a hearing or have their view heard. You're right. I hadn't thought of it in that way. Thank you, Frantz.
It seems like the attendance at these probate mediations is going to go up significantly after this case. But Neil, I wanted to ask you whether, you know, would this holding go beyond the probate courts, or is this really specific to, you know, probate practice, trust wills practice?
I think it's limited to the probate court. I suppose, you know, in another context, you know, in a civil matter where a civil judge orders a case to mediation and maybe one of the parties ignores it, somebody might, by analogy, apply the reasoning in this case. But I don't think the language in the case itself intended to go that far.
Mhm.
All right, well, let's just quickly do our last case. We'll talk about some things that are going on with RPLS. This is a case, I put some numbers up there in the facts part of the screen, talking about really high value property, 133, almost $134 million property. There was a change in ownership of the property, happened to be in San Francisco. The city imposed a transfer tax. Well, look at the size of that transfer tax, $3,348,000. They, in this case, Ashford, the property owner, applied for a refund. Ashford's claim was, well, wait a minute, for properties of X dollar value, the transfer tax is whatever, you know, I'm just going to make up a number. I don't know what the actual tax is, you know, 1% of the property's value. But for property values that exceed a certain amount, let's say the transfer tax rate is, you know, 1.25%. Again, I don't really know what the transfer tax rate is. And I can't do the math that quickly in my head right now either. Okay. And then for properties that are even a higher value, the tax rate that applies for the transfer tax is a different rate, but it applies from $0 all the way up to the total value. So it's not a progressive tax rate where there's, you know, 1% until you reach a certain dollar amount, and then a certain percentage for the next range, and then a certain percentage after that. The percentage, the higher percentage applies to the entire value of the property. So the argument was, well, wait a minute, that's a violation of the equal protection laws. You're treating different people differently. The court looked at this and the court says, well, wait a minute, as long as there's some rational basis for the differential, then it's okay. Says there is a rational basis that has more to do than just, you know, ability to pay. So I have my little picture there on the screen. You know, basically some people are saying, oh, this is just a soak the rich, you know, kind of statute. Those who could pay, you know, should pay more, and that's just the way it is. But the appellate court said, well, wait a minute, there is a rational basis. When cities have to evaluate transfer taxes, they may have to audit the properties. There's a big difference in auditing a $133 million property than in auditing, let's say, $1 million home in San Francisco, which is, you know, probably not much of a home at all in San Francisco. And so there was a rational basis for having the differential in the tax rates, even though the differential applied towards the entire purchase price, and it was not a graduated differential. So, you know, different rates do not necessarily mean unequal treatment under the law. Again, dealing with, you know, real property issues, transfer tax issues. So I thought anybody, you know, might want to take a look at this if you're involved in that area of practice.
And also, speaking of taxes, that's also very related to Joel's question, which he finally sent me in the chat. And his question was in reference to taking property out of a trust and, bouncing it in and out of a trust to refinance if it would, if it could trigger a reassessment for Prop 13 purposes. And typically when I see those kinds of bouncing in and out of trust situations, those are usually intra-family transfers, which don't trigger a property reassessment. But the big caveat there is you have to bounce it in and out of the trust the right way, because it could trigger a reassessment depending on, who it's bouncing out of the trust, who's getting it, and then who is taking it afterwards.
Right, I think, Frantz, part of that consideration is you cannot change the ownership interest. You cannot change the proportional ownership in the property when you're going back and forth. I think that's a significant issue in determining whether there's going to be a reassessment for property tax purposes.
Yeah, and this is actually an issue that could come up with an LLC. Tax things come up with LLCs all the time, where the proportional ownership interest in an LLC which owns a property changes, and for whatever reason, for taxes or some type of reason that the people have, and that can trigger a reassessment. So I think the lesson here is talk to a tax attorney if you're going to do anything involving moving property around, because it could trigger a tax assessment. And if the property is worth, $133 million, that could be a $3 million mistake if it shifts ownership.
Pam, did you want to, address that at all?
No, I feel that Frantz was spot on. Yes, and it is always scary when you are transferring your property in and out. As an estate planning attorney, though, I do, of course, do it when we're doing our trust, but we are very careful with making sure that they are transferred in and out the proper way, because there are instances where we do have to transfer it back out. And just like Joel was asking, just to refinance or for some other reason. And so we're very diligent. We do our due diligence when it comes to making sure that we're doing the paperwork correctly. And even though I do estate planning, every once in a while, I will pull in a tax attorney, depending on what we're doing, to make sure that we're doing it right and that my clients aren't hit heavily.
So, Tom, we know that you deal with a lot of clients who are, who probably own properties, like the one in Ashford here. So do you have any advice before we just, make our last few announcements?
All your points are well taken. And I would say that the where people get into trouble is they make a modification to the ownership structure, the membership structure of, for example, an LLC, beneficiaries to trust, or the settlor trustees. Those changes happen without thinking about a future transfer. And then years later, somebody makes a transfer and it can be an issue. And just be cautious, because these things can get, the reassessment comes and, you claim your exemption, but there's some jurisdictions that may not just buy off on that. So, you want to make sure that it's correct. So that means doing your due diligence, not just signing a preliminary change of ownership form or claiming an exemption on a deed. Your due diligence, echoing all of your concerns.
So Tom, do you think a lot of that happens because parties decide they don't want to pay attorney's fees and they just figure, oh, this is easy, they'll do it on their own? Is that one of the reasons?
I think it's kind of a shame, but I think in the, some people don't want to, like in the corporate world, this is more routine to look at things like that. But it's a shame because some people just they just aren't aware. They might be relying on an escrow officer or, a realtor instead of going to their lawyer, and they get into trouble.
Okay, so that's great advice, Tom. Thank you. Well, let's just round ourselves out here in the last minute. Some upcoming webinars, take a look at them. I've got some good ones. Some speakers that actually we've had here on What's Up With Us, JJ Sherman, Pam Westoff, so on June 8th and June 10th. You want to contribute to our e-news publication, the 10th of every month. We have a summer cannabis series coming up in June, July, and August. Women in Leasing Conference, virtual again this year, spread over 3 weeks in June. Tom, we're going to talk about this again later in the year, the Crocker Commercial Symposium, which you're one of the co-coordinators of, so we're happy to do it. And hey, if anybody's interested in a sponsorship opportunity for the RPLS e-news, our journal, our webinars, we're actually having sponsorship for our webinars coming up. For our virtual events, I don't know why, but we're not having sponsors for What's Up With Us, but we'll have to work on that going forward. But if you're interested in any of those things, just contact me. I'll get you to the right person. I'm Neil, K-N-E-I-L-K @CAR.org. Well, I see we're pressing right up at 1:30. So Frantz, I want to thank you, one of our regular hosts. Tom, I want to thank you for being our special guest host and for giving your insight and wisdom on all these things we were talking about today. And a special thanks to Pamela Brown McGill as our special interviewee. Frantz and Tom, I'll let the two of you take it away.
Well, thank you so much.
And I'll hand it off to Frantz for the final word.
Oh, thank you. We're going to have to figure out like the who's going to start speaking thing as we move forward. Again, yes, thank you so much, Pam, for being with us. It's always a pleasure to talk to you. And just want to give a shout out to the Health and Wellness Committee. The Health and Wellness Committee will be doing some events moving forward. They'll be talking about food and plant-based nutrition. I believe sometime in May. We'll be doing yoga if you're interested in finding your center. And yeah, I think those are the biggest things that we'll be doing in the Health and Wellness Committee, but you should join us. Improving lawyer wellness is really important. And we will see you next month.
Bye, everybody. Thank you.
Bye.